Hi. Hi. Good morning. Good morning. So I jumped on stream early because uh, there's protest going on outside the courthouse right now, and I wanted to jump on and cover it. So hello. Hello. Okay, so if y'all are not familiar, oh, so tired already. I've been up since 4 a.m. If y'all aren't familiar, my podcast that I just started doing, we did episode 1. Numbers on it were great, which is awesome. Part of the reason numbers on it were great is because this is one of those cases that is just too crazy to be real life. So having said that, right now there are protests happening on the courthouse steps, and we're going to go live because I want to show it. If y'all have heard me talk about Turtle Boy before, he is one of the ones who's been covering. I first saw him on Surviving the Survivor, and he and Wendy Murphy kind of went at it, which was entertaining, but also, she's something else. So his style, I have told y'all, like, his style is very different from mine. He is much more like abrasive, but it works for him. Look, he gets stuff done. But he has spent a lot of time looking into this case, like a lot of time, like every day for 5 months. And he has broken a lot of news. So I want to make sure, like, I give him, credit for what he's done, because y'all know how I am. I don't want to take credit for anybody else's stuff. And actually some of the connections that between some of the people that are going to be coming up in the podcast, he's the one. And I'll each episode, I credit whoever. If it wasn't something I found myself, I credit whoever it was. But having said that, he is the one who has found a lot of the connections. It kind of lives in the area, so he's found a lot of the connections between the people. But he's at the courthouse protesting right now. So I'm going to we're going to watch his YouTube for a minute, because he is there. He is there protesting.
4 pieces of taillight, to be exact.
They just had. Hold on, I want to rewind a few minutes. And look, I'm going to tell you, like I said, I'm letting y'all know like I said, his style is different than mine. He does use more cussy words than I do, etc. So I'm warning y'all ahead of time, but I think this is too important not to share since we're covering the Karen Reed case so in depth. I want to go back a minute ago because he just had Karen Reed's dad came. This is Turtle Boy.
Oh, nice to meet you too. Doing a fucking great job. Well, thank you, sir. I appreciate it. Somebody's got it. Somebody's got it. And here's Mr. Reed.
This is Karen Reed's dad.
So much. Thank you so much.
Mr. Reed, nice to see you.
And this is his YouTube if you want to follow that too.
Thank you. Thank you so much.
I'm Clayton.
Okay, oh, nice
I
to meet
meet you all the time.
Okay, nice to meet you.
Stay strong. Stay strong.
Brave man right there.
What's that? Oh, okay, looks like you're in there. While you're down there. All right. Maybe, I doubt it. That's a good picture. Free Karen Reed! 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 Free Karen Reed!
Free Karen Reed. Free Karen Reed. Free Karen Reed.
I'm going to put his information down here too, so y'all can see who he is.
They didn't say what?
They said no public going that way. I asked all witnesses, they didn't say shit.
Okay.
Hold on, wait. Let me get.
We mean that no harm. We don't hurt.
I'm trying to show the dad.
We're not like them. We don't throw dead bodies on the front lawn.
All right, this is the dad.
Yeah, just talk right into it.
This is for Karen and for all of you.
Good morning.
Good morning.
Good morning. Aiden, help.
I'm the proud father of Karen Reed. Be courageous. Be factually innocent. He framed Karen Reed. We will not stop. My family is so strengthened by this outpouring of citizenship from all over, fighting back against corrupted institutions. If we lose faith in our institutions, this country is not what it was built on. So I want to thank you from the bottom of my heart for taking time out of your day, out of your schedule, to come here and support. In support of freedom, support of justice, support of integrity, honor. No, of course she didn't do it. She did not do it. Look at the injuries. Look at her car.
That's a Brian Alvin move.
Stop there. Look at the injuries. Look at her car.
Where's Chloe? Look at the difference between the Brian Walsh case and the Karen Reed case. Totally different investigating. By the same investigator.
My daughter will be here in a few moments with her immense and talented and dedicated and committed lawyers.
Yes.
That's Turtle Boy.
Lawyers who are
I got
competent,
it. Thank you.
smart as hell. We'll get this thing unveiled. Thank you so much again. Thank you from the bottom of my heart.
Thank you, Mr. Reed. Yes. Oh, Kelly Reed, how are you? Nice to meet you in person. Karen's cousin.
Karen has such great family. They have such great family. Her brother, her cousins, her uncles, her aunts, her parents, they're all here for every court hearing. And as you just heard,
Hold on. I'm going to swap to the other so that I don't have problems with it freezing.
That happened. And they tried to shut us up today, which is just poetic. They don't realize how stupid they look, how dumb they look. They did exactly what we wanted them to do. They tried to shut us up. They proved our point for them. But we're not going to stop. I don't know. Why do you bother Michael Morrissey? Do you really think crime scene tape is going to stop us? You fat waste of space.
All right. So like I said, he's a lot more abrasive than I am. Just throwing that out there. This is the
do some keto diet. You look disgusting.
this is the protest right outside of there. Now, the banner I have at the bottom has his website and it has all of his news on there, but he does a ton of like he has a ton of reports on his stuff, documents and stuff like that. I had never heard of him until I started looking into this case, and then his name kept coming up. And like I said, he's a lot more I know some people like different styles, but that's kind of another thing that works well with me covering this case is that a lot of people who, in our chat and our, people who listen to me or watch me have never heard of him or don't know much about, that community. So we're looking for we're going to two different audiences here, which is great because the more, the more eyes that see this, the better. So.
Okay.
They have not set the trial date yet. This is a pre-trial hearing today.
Well, anybody can go in at 8, right?
I'm going in when her family tells me.
Yeah, absolutely.
So the courthouse is, I mean, it's a public courthouse, but obviously the seating is limited. I'm sure somebody will be streaming it in here. I got a hot spot, so hopefully I'll be tweeting in there or something to see if it works. But
You want mine?
no, we're good. But watch it. I mean, I'm sure you can watch it on Zoom.
Let us in, guys.
I think it's going to be the longest hearing today because there's a whole bunch of motions.
This is Boston area.
And, you know, Auntie Bev, she doesn't like to work in the afternoon. She got frustrated. She wants to go home. She likes to talk at it too. But, you know, yeah. What's up?
It's 8:30.
Yep.
It's 8:30, and we're going to open up the doors.
Okay.
And we're just going to be as controlled as possible. Okay.
Okay.
But there is a capacity issue.
Yep.
Okay. So when it gets to a certain number inside, you're going to have to cut it off.
Okay.
Okay. Thank you.
So, yeah.
So, but I'm just getting like this is the entrance on this flight of stairs. We can't have both.
Okay, so you need the stairs clear. I mean, that's why it would be very.
That's why
Why don't we just let people go on the side then? I mean, that's the problem with that? This is poor planning. This is really poor planning. They don't want us congesting the sidewalk, which a great way to avoid that is just take down this privacy tape, and then all these people can go up here, and then all those people can go over there, and then this won't be blocked. Again, I'm not a rocket scientist. I'm not a rocket scientist, so I don't know. We have justice for John and Karen. Love it. Justice for John and Karen. Justice for John. Oh, there he is. Perkaki! Boo! Boo! He covered up the murder of John O'King. He covered up the murder of John O'King.
So the one that they're booing right now, if you watched or listened to the first episode of the podcast, this is the that is one of shame on you, they're saying. This is wild. I'm going to stream the hearing when it starts. We're going to watch this until it...
You want to hold on to it? All right. What time is it right now? 8:33. 8:33. Okay.
So the...
So listen, I'm going to go in. I'm going to be going into the courthouse in a minute, guys. What was that? Are you trying to do a delivery? For you. Oh, for me. Oh, I'm going in the courthouse.
Please don't put me on camera. You get delivery?
I'm doing live. I'm going inside.
Is it free?
Put it on the side. Put it on the side. I'm going inside.
All right, you want me to hold anything?
Matthew sent it. Okay, it's paid for. Hey, all right, guys. Look it. I'm going in.
If you don't mind, we're just trying to keep everyone come up here so we can pull people up this way down the other side.
Free Karen Reed! 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 All right, guys, I'm going inside. We're going to court. Tune in. I'll be here right afterwards. We'll have a post-conference. We'll see what happens. Watch it on there. Watch it on the Zoom. Watch it on whatever the streaming service is. We'll be in there. We're going to get justice today. And if we don't, we'll be back. This ain't the last time we're going to be here. Peace.
Okay, so wrong button. All right, so here's the thing. That is a lot happening. I know. and I know it's early, but the reason I wanted to go early was because there is so much happening. Let me get it pulled up. They are supposed to be streaming the hearing, so I'm going to pull it up. I think I have to pull it up from the local news, so let me get that pulled up. We're going to watch that, and let's see. Let me search this. The officer that came in where they were saying, shame on you. If you listen to the first episode of the podcast, it gives like an introduction. This is one of those that is so complicated. Like so complicated. And every time I thought that it was every time I thought that they had or that I had figured out all of the connections and all of the details, then something else would come up. This is probably one of the most, like, I thought that Murdaugh was a complicated case, and I kept calling these when I first started looking into this whole case and everything. Like I first had mentioned it to y'all, and I said, I felt like I said weeks ago, I felt like these were like this is like the Boston Murdaughs. So, but this is it's even, I'm telling you, it's even more complicated than that. There's so much. And I had mentioned in the podcast because I don't want to take credit for anybody else's stuff. Like there are, y'all know how I am with documents and putting stuff together. So I have Sleuthy Goosey, who, if you don't follow her, you should. She's like I am with the document stuff. She's on Twitter, and then Sleuthy Goosey, you're here. Hi, Sleuthy. Hi. Why can't I find a single news channel? I don't think there are some. I'm going to pull it on Canton Community because I believe that's where it has not.
Massachusetts is a scenic ravine of cascades and so forth.
What the heck is that? I have it on the Canton Community stuff. Trying to decide if crowd believes Karen Reed is innocent or if they just believe in whatever Turtle Boy believes. Well, okay, see, and I'm glad you mentioned that because y'all know I am not a conspiracy theorist type. And I don't normally get into all of the like, police set us up type stuff. Like that's not normally my jam. The thing is, when I started digging, there are so many things that don't make sense. And it made me start questioning things. And anytime, if I find one thing that doesn't make sense, and I'm always like, I don't really believe in a whole lot of coincidence, for the most part. So it always kind of makes me question things. But then the more I started digging, the more I was like, okay, this isn't just one thing that doesn't make sense. These are a lot of things that don't add up. So I started going through court documents, and Sleuthy has a great, she has a great Google Doc that has like a lot of the court documents together and stuff. And I started kind of like reading through stuff, and I immediately started seeing inconsistencies, things that didn't add up, things that didn't make sense. And then I started listening. I was like, okay, well, let me find the two loudest in the room. Why is everybody fighting? Let me find the two loudest in the room. Who's fussing about whatever? And let me hear what their biggest thing is. So I listened, and I was, and the arguments, like the main arguments for each side that were so passionate, you know, for me, it was like, okay, one of these arguments fits and makes sense, and the other one doesn't. So for me, I was like, okay, oops, I don't know what I just did. There's only so many things that you can like brush off as coincidence or, you know, mistakes in an investigation, that type thing. There's only so many things that you can really do that with. And for this to be so many, and the first episode of the podcast that I did is like a very basic introduction. As the podcast goes, I'm kind of going to, because it's so complicated, it's way too much to put all into one episode. So the way that I've laid out kind of my plan on the outline is to walk through the investigation, and then as it happens, and then for each of the like main controversial pieces of evidence, I'm going to do one episode, and I'm going to bring in experts and people who like, because doing this, for a living, I have some really cool contacts that I can, ask about who are constantly, testifying in high profile murder trials and look at this kind of stuff all the time. So that's kind of cool to, be able to be like, hey, like, so much about this. Tell me your thoughts on it. So I want to I'm going to dig into each piece of evidence. The biggest things, if you haven't listened yet, or if you don't know much about it yet, and I've got the Canton community thing on over here. It says, they are going to be streaming it. So I'm just waiting on them to start, but I've got it
called Headshot.
Mute it. Right now they're playing, I don't know what the heck this is. It's an author presentation with something. I don't know. Anyway, but I've got it on over here so that when it starts, we can jump right in. But if you, the biggest part, or the biggest thing to know about this is that there was a, they're saying that Karen Reed and her boyfriend, they had left the party. I've got charts up on my Twitter and on the 13thjurorpodcast.com website that show kind of who's who, because there's so many people involved. But basically they were, out at the bar. They went to the Albert's house, and their story is that she dropped him off. She was angry, and she did like a 3-point turn, ran over him, and then left him there to die in the cold. So there are photos of her car, and the back tail light is busted out, but there's no other damage. And the way that his injuries are, and like the autopsy and stuff, like it's not consistent. And a lot of people believe, I'm not an expert in that part, but my friends are, so they'll be coming on the podcast too, and I'm excited for y'all to hear what they have to say. But the injuries are not what you would look at and see like, oh yeah, he totally got hit by a car, and then you look at the car and you're like, yep, adds up. No, it's just a taillight, and that's hard for a lot of people to understand. How can you say that he got these kind of injuries? He has parallel lacerations, and it's only on the right arm. And I guess the state is saying that that's because she ran over him, and that's what caused it. But they also said that there was a hair in the taillight, and that was tested, and it was not a hair. They were trying to say that was, John's hair, and it was not a hair. They also had, this is on the night of, oh, Annie, oh, hold on. I love my little anniversary thing. Happy anniversary, Annie. I'm so glad you're here. 4 months. It has gone by fast. So fast. All right. So the search that was done. Now, keep in mind the people, like he was a Boston police officer, and the homeowner was also a Boston police officer. His brother is a Canton police officer. His daughter is an investigator for the Attorney General's office. He's one of the other friends that was there has an office in the Canton Police Department. He's task force. So there are a lot of connections within this family and group of friends. And one is on the select board. So there's a lot of connections. And so he goes to their house, and they have, you know, the timeline is around 12:30. He gets dropped off and allegedly run over by Karen, and she leaves and goes to his house and goes to bed, wakes up, he's not home. And then she freaks out and is calling around trying to find him, goes to find him and finds his body in the yard. So they're saying that she, you know, ran him over and then went home and then came back and found him. The problem is when they did the original search, it was as the storm was coming in, like as a big blizzard was coming in, not a lot of snow had fallen yet. And they were able to, when they did the search, Canton police did the search out there, they had like the blowers or whatever, you know, that were able to kind of, because there wasn't a lot of snow yet. So they were able to like kind of that area around him, you know, like get the snow cleared from that area to search. They found a cocktail glass, which I mentioned in the podcast. He has the glass in his hand when he leaves the bar. They found that, which is a clear glass, a clear cocktail glass. They found that, but they didn't find any pieces of taillight. So then fast forward, that's like, you know, early morning, fast forward, and all of a sudden there's the state police take over, and I mentioned in the podcast, Trooper Proctor is the one who comes specifically to take over, and he has close family ties to the Alberts, and so he should not be on the case. Honestly, he should not be on the case. So they take over, and then all of a sudden they find red taillight pieces. So me thinking logically, how do you find clear glass in the snow, but you miss 35 pieces of bright red taillight? That's a huge red flag. That was red flag number one for me. Then the phone records come out, and one of the, and it's too complicated, look at the charts, but it's one of the people connected to the homeowners. It's the homeowner's sister. Her phone records come out, and she did a Google search that was deleted at 2:37, I think, in the morning is what time it was, for how long to die in the cold. So why would you be Googling that why would you be Googling that? If he never came in the house and you don't even know that he's out there. There are some other inconsistencies that I point out in the podcast. Like I said, it's so complicated, and it's, you know, it's too much to try to go over all of it now, but those are kind of like some of the main points to know for now. Happy anniversary, JT's member for 3. We've been a member for more than 3 months, but happy anniversary anyway. Happy anniversary anyway. All right, let me pull up the community stream and think do it like this. Let me make myself a little bit smaller. I don't know if this is going to be on the news or not. I've heard conflicting stories that it is, so I have the link to the community stuff so that we can watch, because can't miss this. Yeah, it's not just a red flag, it's red plastic taillight pieces. And there's so much more. Like I kind of, on the very first episode, like I kind of dug into some of like, or not even dug in, I kind of like mentioned a few of like the original questions that I had, because I sat here overwhelmed trying to figure out how to write this first episode, because like I said, there's so much that goes into this, and it's not even scratching the surface yet from what I even mentioned. But I was like, okay, the only way that I can really lay it out is to walk through the investigation and then dig in, because it's like you have to get a general idea of what the heck is happening before you can even like begin to dig into all the extra stuff, because there's so much. It is wild, y'all. It is wild. Well, I've only wanted to support myself for 3 months. Ha ha ha. Ha 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 ha. Took a while for me to believe in myself. We all believe in you, JT. We all believe in you. Future says, I've been listening to true crime podcasts for years. I've listened to countless pods, and I'm pretty picky, to be honest. Me too. Your podcast was very well done. Can't wait to hear more. Oh, thank you. Thank you so much. Thank you. Thank you. So far, people have seemed to really like it. I've only gotten one person who didn't like it, and he didn't say he didn't like it. He said he didn't like that I sounded biased. And I was like, it's the first episode. I don't even have time to be biased yet. So the first episode is literally all of the things that make this controversial. So if I didn't point out all of the things that make this controversial, then it wouldn't be, what would be the point of doing it? Like, I can't tell just one side. So I have to say all the things that are questionable. But he took that as me being biased, because I was pointing out all the things that I think don't add up. Yes, Turtle Boy is from Massachusetts. He got involved. He's a journalist anyway. He's covered other things, but he got involved with this and then just hit the ground running. So he's been a huge part of this. So I mentioned him in the podcast too, but because he has done a lot of work on this. We don't have an actual trial date yet. They have been going back and forth, or not back and forth, but they've been going through the process of doing a whole bunch of pretrial, hearings, because there's so many controversies in this case with cell phone records and cell phone experts and deleted calls and searches and what those deleted calls and searches mean and what time they really were. And there's a bunch of explanations for the time. There's not a bunch. There's one explanation for the time being 2:27 when they say it's not really 2:27, and their explanation makes literally zero sense. But that's everybody's going to have an expert to say what they, whatever. So there's been a lot of pretrial hearings and arguments over this, and and as we cover this on the stream too, because this is I've only done the one introduction, and even that introduction was short. I was so tired. That was when I was functioning on 8 hours of sleep in the last 4 days or something. So we've only really just started to even scratch the surface. But as we progress things, we'll watch the previous hearings together and stuff too. I would think it's going to be on the news. But let me look and see if anybody else covers it. But this is, should be starting soon. Let's see. Let's see. Wow. Trolls, trolls. You are a troll. All right, there we go. There's also a feed on another channel. Let me see. We'll watch whichever one has the best feed. Did y'all see that Richard Allen wants his trail? Drink another cup of coffee, Brandy. Wants his trial televised. That came out today. All right, let's see. I'm going to pull up the 2 different feeds that I know of, so that way we can make sure we get the best video and audio and all that good stuff. It's our anniversary. Let's see. Okay. It's supposed to start in 3 minutes. I'm excited for this, y'all. I am excited. All right. I've got this one pulled up too, so we'll see if I can kind of keep an eye on both and see which feed is better. I think I have actually. I can't see over there. Keep that one up for a minute. I thought NBC Boston would have it because they've been covering this a bit, but I don't see it on theirs. So I'll watch both and see who has the best audio and video, and we'll make sure that we play the best one. But we'll keep watching. This one hasn't started yet. All right, so let's see what else we got going on. Good morning. Good morning. Hello to everybody just joining us. It is early. It is early. Good morning. Thank you so much, White Paint. It has been a labor of love. I think it's such an important story to tell, and I want to try to tell it in the best way possible, because I do want to give credit to some of the questions that, you know, there are some things that don't make sense with, you know, with both sides. So I want to acknowledge those. So I want to try to present this in a way that is honest, but also like realistic. But also, not every single thing is going to make sense because we don't know exactly what happened. There are always going to be things that, you know, will come out later, or some things that we'll never know. But I want to try to focus as much as I can on facts and then be very clear when it's theory. Let's see. Hello, hello. Good morning. I see some of y'all still filing on in. The live view has started on the one I've got on this screen. The live view is like, it hasn't started, but it says live view. And then on this one, it's the Zoom. So we will see which one has better. We'll see, because they have live view on Court TV, and then I have the Canton stream on this one. So, but we'll make sure we see whichever one's whichever one we can see the best of and hear the best of. All right, let's see. Good morning. Good morning. I see some new faces in here too. So hello to those of y'all joining in. Amy Bo, we have a new member. Oh, wait.
What? Did we just become best friends? Yep.
Yep. Welcome. Welcome to the group. Glad to have you. Glad to have you. Oh, you grew up in that area? Oh, that's cool. We've had a few Boston people. That other trial that we're covering right now, one of the other trials, because I'm covering 3 at one time. That makes total sense, right? As if I have all the time in the world. The other trial that we're covering is I got corrected. It is not Boston. The attorney is from Boston, but it's from it's Massachusetts. So we had some other people that had grown up in either the Boston area or like suburbs. How do you call it, suburbs? I got. If people say things differently in different areas, you know, and so I say things the way that Georgia says things in Florida, because now I'm in Florida. But Lord help me, if I say the wrong thing, then everybody's like, that is not what it's called here. Let's see. Yesterday went by so fast because we were busy trying to watch all the trials. Yeah. Oh, and I got something sent to me too, that the one trial that we're watching, the sex therapist trial, I guess they subpoenaed Drew Carey for to come testify. So we'll see. We will see. We will see. Brandy, I'm so glad you're doing this case. I live north of Boston with a wicked accent. Okay, so people were trying to help me do my Boston accent the other day, and I failed miserably, apparently. But I can't remember what they tried to have me say, but apparently I failed. They said I was awful. Today should be very interesting in court. Karen's bond was high because of the infamous hair. So I hope defense goes in on the state about this today. So this piece of hair that was supposed to be in the taillight that was like there, you know, we got you know, his hair's in your taillight. And that's one of the things Wendy Murphy was like, it's a human hair. Well, it's not a human hair. Bless her heart. She's wrong. So, they tested it. It's not a human hair. And so now they're like, so what was that you were saying about human hair? Not true. So we'll see. The bond being so high and just with that being such a critical piece of, you know, evidence in their story, it's going to be interesting to see how they bring that up now. Melanie, member for 1 month. Love this channel. Brandy, you are the best. Thank you so much. Oh, hold on. Oh, no. My sound effects stopped working. What the heck? They were just working. What did I do? I'm always pressing buttons. What did I do? I don't know. I did something. Well, it's our anniversary, Melanie. Happy anniversary. We're glad you're here. I've got like 4 different. Oh no, what's happening? I got so many different things up trying to make sure we have the best. All right. Yes, I have a chart. Thank you, Brooklyn. Yes, I have a chart of who's who and who is at the bar and who is at the house. And the who's who is not even close to being done. Like I said, this is like just the beginning of the stuff. There are more people who come into play as we go. Let me move myself out of the way a little bit. There we go. It's supposed to start at 9, so like 7 minutes ago. So should be. So this is Karen Reed's dad. I need a lip reader. I need a lip reader. I need to know what they said. Her attorneys are really good too. I've been, which it's been hard because there's I mean, bless his heart. I feel bad for both families involved. I feel bad for Karen's family. I feel bad for John's family. I don't feel so bad for the Alberts, but I do feel bad for them. And Paula's good looking, y'all. So is John. Thank you so much, Aussie Gardner. Thank you so much for the super chat. Big hugs, my 13th Juror family. Thank you so much. We are glad you were here. If you caught us when we first went live, I showed Turtle Boy had protests going outside. So Karen's dad, what happened? So Karen's dad got on there. Well, they're cheering for him. If you don't know much about, I put a little description in the description of this video. So if you want to, if you don't know what it is, you can read that to give you a little bit of an idea. The district attorney is not I'm not a fan. I'm not a fan. And I'll get into a lot more of that later, but I'm not a fan. I don't care for him at all. At all. Let's see. Good morning. Good morning. Hello to those of you. Okay, so like about every 3 minutes, somebody comes in and asks me to summarize again. So rewind a little bit to the summary, or it's in the description is in the description of the video. I love y'all so much, but I can't summarize every 3 minutes. I'll lose my voice. This is defense right here. So this is Karen and her attorneys. Her attorneys are great too. Volume's all the way up. Well, let me see if I can.
So today was, originally it was just scheduled for status on motions. And remember the last time I did ask you to put in writing exactly, still out.
Turn on the audio.
When you thought that we would get things to the defense. So since, and we'll do the motion, since that time, counsel filed additional motions. So there have been, what I understand, what I have is 2 Rule 17 motions filed by the defense, one essentially for records from Canton for every guy. Was that Zoom chat? Second is a motion for the second, it was a motion for the next over here. 3 filed by the Commonwealth, footage regarding a motion for the video, defendant's father's home. So whoever's on Zoom, you have to be muted or we'll throw everybody. Motion for records from ABC and NBC essentially. And then you are the host would like you to your microphone. You can press star 6 to unmute. Jim, do we need to start again on something?
Video footage from the defendant's father.
And then there's a recent motion regarding exhaustive testing. Then there's a motion for me to review conditions of bail. And we're also going to set a scheduling order.
Actually,
these piecemeal Rule 17 motions coming in with an affidavit in possession of counsel since January 2022. We're not going to keep them. We'll set firm dates. So before we start the motion to compel, have the third-party record holders been given?
The Zoom audio is not any better.
By Mr. Lilly?
So yes, with respect to each of the respective 517
Hold on, I'm working on it.
So yes, with respect to each of the respective 5 Rule 17s from both the Commonwealth and the defense, I did send notice to all the third-party subjects and all the third-party record holders.
Okay. Did you get any responses from anyone?
The only response I received, Your Honor, was from Attorney Gregory Henning, who represents Brian Albert in reference to the Google Nest situation.
Okay. Does he want to be heard?
I believe so, yes.
Okay. Is he here today?
My understanding is yes.
Oh, okay. Good morning, Ms. Henning. All right. So it makes sense then to start with the Rule 17 motions. Nothing from, were the record holders given enough time, Mr. Lally?
As it pertains to the Commonwealth motions, yes, I did receive this latest one just late last week. So as soon as I received it, I sent notice. But so it's been at least approximately a week or so that they received notice.
Okay. Does the defense have any reason to believe that there are record holders who haven't been given enough time and you expect them to be in today?
Your Honor, with regard to it, let me just step up.
That might be easier.
Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from, or with related to Mr. Lally's motions, NBC, ABC, alarm.com. Is that what the court's talking about?
I'm talking about all of them. Do you have any reason? Mr. Lally sent that he sent out notice to all of the record holders pursuant to Rule 17.
Right.
And that he only heard back from one person. I know some of these motions were filed late, so my concern was that some of these record holders did not get notice. Yes.
Just one addendum to that, Your Honor. I did also speak with counsel for the town of Canton, and they have no objection to the records, not
okay.
the Commonwealth, but I did speak to her as well.
Okay. Does that answer your question, Mr. Jackson?
Not completely. As it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17 B motions on, I do have an issue with because I contacted, I don't have enough information to be able to state with any authority that they have not received consumer notice. However, in speaking with both those entities, producers at both those entities.
Did you speak to legal counsel? Because that's where it went, right?
Correct.
I have not spoken directly to legal counsel on either side, but for either agency. However, I was told by individuals who had spoken to legal counsel that they had not been served. They had not received any formal paperwork from the Commonwealth as yet. And that was probably, I want to say, 5 days ago, something like that, 5 or 6 days ago. So that's the latest information I have. In other words, I don't have information that they haven't gotten notice, but I certainly don't have information that they have gotten notice either.
Mr. Lally, I don't want to continue this Rule 17 motion hearing, but what's the Commonwealth's position on that?
Your Honor, the Commonwealth's position is notice was sent at least 2 weeks in advance of the hearing date. On those motions. I haven't heard anything from either of those parties. It was addressed attention to legal counsel for those entities. If the court wants to push it off to a further date for me to provide additional notice, I'm okay with that. But at the same time, I don't foresee being any issue. And obviously, you know, if the court were to allow the motion and order the records and there was some objection to them, certainly no records would have to be produced until at such time as they could be heard.
All right. What I'd intend to do is go forward on the motion today. I will, in all likelihood, take it under advisement. And if we hear from them that they did not receive notice or they get late notice or they want to be heard, I can reopen it. So
that's satisfactory with us, Your Honor.
All right. So since you have, well, the one that seemed the quickest to resolve is the Canton Town Clerk motion. Mr. Clerk, that's paper 116.
Thank you, Your Honor.
So in reviewing that, I sort of assumed it was something that the parties might agree to, and you say the Commonwealth agrees to that, Mr. Lally?
No objection, Your Honor, no.
Okay. All right, so I will allow that. I'll take a closer look at the proposed order. That motion will be allowed. All right, Mr. Clerk, I'm going to hold on to that to take a close look at the order. All right, so why
That was 116.
116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up since this affects your client as the third party? Okay. So why don't I hear first, I just like you up here, why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you standing there, but why don't I hear, I guess you'll have to take a seat. Why don't you just sit behind? Thank you. I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant, it's material to the defense, and it should be material to the prosecution, I would think. It should be material.
I have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition.
There may not be, but there may be an opposition from, it sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself.
The motion being allowed, no. The only objection, and that's why the Commonwealth
This is a long-time law enforcement officer, Brian Albert.
I'm actually going.
Seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no objection.
I do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm going to ask you to have a seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
Good morning, Your Honor. Greg Henning on behalf of the homeowner. With the proposed order that the Commonwealth submitted in that language, Mr. Albert, the homeowner, has no objection to the Rule 17.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th. We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth.
Did you see number 3 of their proposed order?
Proposed order is. I can have just a second.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number one says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's one. Number three. The Commonwealth's proposed order is more expansive than the defendant's proposed order. Objection to that, I'll hear you.
But obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor.
We both received it. I mean, I can read it on my phone as well as I can read it on the on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page, and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number one that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number three is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number one, excising any sort of other Google account information. Which
And I think Mr. Jackson just said he didn't have an objection to that. All right.
and expanding the time frame.
Okay.
The only wording that was changed on under number one that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, any setup inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of a Google Nest activation system. In other words, the setup, I think that's a throwaway line, and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. If sum and substance is that we get the Google Nest data, that's what we're concerned with.
Thank you, Sharon.
All right. And you prefer that I add the expansive time frame than the less restricted time frame that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection from the homeowner. So thank you for coming in for that, Mr. Henning.
Thank you so much.
So now we'll do the Commonwealth's the motion for the alarm. Is there an objection to that, Mr. Jackson or Mr. Yannetti or Ms. Little?
Not from the defense.
Okay. So this is the Commonwealth's motion for records alarm 121. Did you propose an order with this, Mr. Lally or Ms. McLaughlin? Did you propose an order that maybe I don't have?
Should be an order attached. I can provide the copy with an additional.
You might have it, Jim. All right.
Happy anniversary, Dean Sparks.
Thank you. Thank you.
Morning, those of y'all coming in late.
All right, so Jim, I can give you back that whole Motion. All right, I'll hear the Commonwealth. Do you want to start with, I have first the ABC News one. Why don't I hear you on that?
Just, it makes no difference to myself, Your Honor, but there's also another related motion to that camera.
Which is to the camera one?
Yes, from the House in Dayton. It's a motion to compel to preserve and request for order production.
I don't believe I have that. When was that filed?
Same time as all of the others.
It could, I mean, I just have copies, so it could be that it was filed there. So Jim, it's probably somewhere around 121, maybe 123.
What's it called again?
Is there an objection to this from the defense?
No.
Thank you. Okay. All right, Jim. All right, so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with.
Your Honor, I think we can take them sort of in tandem. It's essentially the same issue, the same type of factual background. Essentially, what the Commonwealth is requesting is any and all video footage, including raw or unused or unaired video footage of interviews, specifically with the defendant herself. She submitted herself to interviews with multiple news programs. The content of those interviews was sort of interwoven within a narrative story, which the Commonwealth would submit as a fair inference that there's additional footage that is available. In specific reference to the NBC, there's an indication from the broadcast that this is part of a larger program to air at a future date. These statements by the defendant, as the court is well aware, are entirely admissible. They were freely given by the defendant. In each of the respective news broadcasts, the defendant, at least in part, so some of the statements she's on her own along with the reporter, and some of the other statements she's seated at a table with counsel. So as it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party opponent. Any statements that she makes to these outlets, she's free to make, but the Commonwealth is seeking production of those statements.
Okay, who am I going to hear from the defense?
Your Honor, at this point, we don't have an objection to Rule 17. I think I know there's going to be a
Speak into the microphone.
I'm sorry. I'm thinking that microphone's going to pick us up. It
will, just be closer to it.
Sorry about that. We don't have a principled objection to the Rule 17 because it's really not our dog in the fight, as it were. In terms of ABC and NBC, if the subpoenas issue, I have every reason to believe that both NBC and ABC's legal department will take great issue with the subpoena for reasons of their own. But the defense is not taking a position on the Rule 17 at this point because it's not our fight.
Okay. All right. So do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think. I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do. Both NBC and ABC are out of state. I don't know that they were served out of state.
Of course,
right?
I think the Commonwealth, yes, they're served. It's right in the pleadings.
But I'm not sure where they serve notice. I just don't know, because when I did check, both legal counsel, both offices, general counsel for NBC and ABC indicated to me through another person that works there that they had not gotten any information concerning this issue. So I would like an opportunity to check with legal counsel.
Okay, so I will.
She does have an interest in it.
I will take the motion under advisement.
What happened?
If they want to be heard, I will give you 1 week for them to give notice to this court by way of letter of legal counsel as to why they did not appear here today. And then we can see about setting up a hearing. And if your position is that you don't object to it and it's just with them, we'll set a date.
Thank you, Your Honor.
All right, so I'll do the same with both of those motions. All right, why don't we do the motion to compel, and then we'll get into the exhaustive testing motion. Is there an objection to the exhaustive testing motion?
At this point, Your Honor, there is.
Okay, so we'll
there's
hear the
some technical
motion.
reasons, but
We'll do the motion to compel first.
thank you.
They have
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your reply.
Thank you, Your Honor. It has now been a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12th, 2022. The compliance date for mandatory defense access to this physical evidence was more than a year ago.
That's crazy.
In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote, I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in discovery about a month ago, this is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello. Person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexus infotainment system and the Lexus telematics system. As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that. The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Stoughton District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of the court order.
So important. I'll tell y'all why.
The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced over a year ago. If you were to review all of the police reports in this case, as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview. That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene. That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes and reports so that we can at least attempt to prevent further fabrication of evidence. The 5th category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
Oh.
Your Honor, I'm not quite done.
Oh, you said there were 5.
I was going to have a conclusion if I
Okay.
finish addressing the court. Thank
Sure.
you. Your Honor, we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Kamal?
Yeah, sure. Most of what I believe was just addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium, please?
That's fine. So, Your Honor, I believe most of this I've addressed in the Commonwealth's response, and just to be clear, it's not an opposition to the defendant's motion. The Commonwealth is well aware of its discovery obligations under Rule 14. It does not oppose the defendant having access to these items. It's merely an issue of timing. Now, as it pertains to the first enumerated item, and there's been various modifications of this, and what I would say is that the Commonwealth is very aware of its ongoing obligations under Rule 14A1A, under Rule 14A4, as it pertains to mandatory reciprocal discovery and exculpatory evidence, and has provided counsel for the defendant with we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is I would submit, withholding evidence or preventing the defendant from doing any, receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some point over the history of this case where I had been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson. My remedy for that has been to provide whatever I can, especially documentary evidence and attachments to email, so that it goes to all counsel and all counsel have access to it, which caused some of the delay as far as the testing in the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then there was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel. What I can say is Ms. Little and Mr. Jackson were very good as far as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July date because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies, they're not my policies. There's nothing as far as anything that the district attorney's office or myself has done, any suggestion that we're desperately withholding evidence from the defense as we're afraid of what it might show is just patently ridiculous. The items that are at the lab are, there's no objection to counsel swabbing anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, there was a recent trace assignment that was completed, not recent, but several months ago, actually. And it had to do with item 3-1 and several other items pertaining to the taillight. And so 3-1 is the passenger side rear tail light of the defendant's SUV. Item 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual unit from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately, probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery or analysis, there was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1. Again, an item that the lab had theretofore thought that they were had completed with. There's also an ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle, comparing it to pieces of what they describe in the lab notes as a cocktail glass that's found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the waterfall bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that trace assignment is open. The DNA results from the July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing, my understanding, should be completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of when items will be completed. But the DNA testing, I anticipate, should be completed on or around September 26th. Those two trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly. As far as whatever the court deems appropriate to impose, obviously the Commonwealth will comply with that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it'll be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab, but if there are any items that have no forensic value left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
do you anticipate that this will be the last round of testing for DNA?
I anticipate it will, but at the same time, it depends on what the other testing shows. So it's typically what the lab is going to do is they're going to test until they get a forensic link, or either they do or they don't. But basically, so without knowing what the results of the testing that's just undergone, is just about to be undergone, or is undergoing currently, I can't speak as to what those results would be, and therefore I can't speak to whether or not there would be any need for additional testing.
Okay.
As it relates to the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion that compels, it's sort of incorporating all kinds of different materials. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should council have an expert that wishes to view or download that material directly from the vehicle themselves. All of that material, including the raw data, has already been provided to council. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just, what I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the CARS unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I've stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Celebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that I'm aware of that pertains to those types of systems, they receive updates periodically from the manufacturer. I believe there's another one coming up in a month or so. But I have no information. We reached out to Burla numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up until we receive an update that can actually read and parse the data that's contained therein, it's an issue as far as, you know, there has been data that we've extracted and we provided to council, but it's essentially unreadable data at this point. I am aware that Trooper Garino from our office spoke with council's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just pertain to the Burla or to the infotainment system. It also would apply to an event data recorder. The issue with the chip-off is that it can be and likely would be destructive. So essentially what it involves is sort of burning the chip off of the unit. And in that process, sort of inherently within that, can be destructive to whatever data or material is in there. And you don't know that until you've already completed the process and started to look at it. And that is the reason that the Commonwealth has not endeavored to do that at this point and has opted to wait and see sort of if we can get an update from Burla or from the manufacturer to Burla so that we can read and parse the data. If that is something that council is interested in doing, again, I've spoken to Ms. Little a little bit about this, that the Commonwealth certainly is not going to conduct any of that testing without them having an expert present to do any sort of chip-off or any kind of destructive testing whatsoever. But if that is something that council is interested in, I would encourage council to file a motion with the court, as would be done with any sort of destructive testing. And if that's something that the court orders us to do, obviously we will be present, and council will have an opportunity to be present with an expert as well. The third category, I believe Ms. Little was referring to notes of law enforcement. Absolutely no issue with that. It's been requested. I should have those in a short frame. If the court wants to order their production within, say, 2 weeks, that's absolutely fine. Reports, notes, and mapping from the CERT team. Again, these are items. What Ms. Little was referring to today is a GPX file that I just received yesterday from the CERT team, and that's why I'm providing it today. Obviously, sending it in the mail wouldn't do as good as handing it to Ms. Little today. But essentially, what I put on that disk is a GPX file, and it's a file that contains data that can only be opened in a mapping software. So in addition to the GPX file, I also put some mapping software onto the disk to make it readable. If council wishes to use a separate software application, obviously they're free to do so.
When do you expect to be able to do all that?
So that was provided today. The other part, as far as notes from the CERT team, there are no notes from the CERT team. I spoke to Lieutenant O'Hara from that unit. There are no notes. They have reports, they have diagrams, they have the mapping raw data. The only thing that I'm currently waiting on, should have in the next few days or so, is in relation to I don't even know if they asked for it, but it's something that I was looking for as far as dispatch logs and ALV data as far as when they were dispatched and when they arrived at 34 Fairview Road, all of which should be logged. Similar to items that's been previously provided in regard to the Norfolk County detective units. As it pertains to Trooper Proctor, 5 undocumented searches of the residence, I don't believe that those occurred. I will certainly look into that, and if there is any documentation related to those, whether they be notes, whether they be photographs, whether they be reports, again, the Commonwealth has no issue providing those in short order. That's something that I've heard of the first time today while I was sitting here in court. Now, I believe the 5th thing pertains to the raw data, which again, the Commonwealth provided this morning. So as it pertains to this or any discovery, there's been a number of other discovery items that Ms. Little and I have had conversations in regard to over the last several months, over the last however long it's been. But I would submit that when I'm asked of things, asked for discovery, formally, informally, whether by formal motion or not, the Commonwealth has no issue with continuing to abide by its duties and obligations under Rule 14. Whatever discovery I have or whatever discovery that I can provide, I'm happy to do so. That is.
Okay, Ms. Little, any follow-up with that?
Oh, yeah. He doesn't believe that those 5 occurred, those 5
Mr. Lally
searches.
just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data, we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I
Okay,
received
so after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data, put something in writing. It sounds like the 2 experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the 5 undocumented searches, we don't have reports on those. Like I said, we have photographs of the evidence bag that shows that taillight pieces were not put into evidence until late February. There were 5 undocumented searches. They came from somewhere. So we need reports on those. And with that, I will submit, Your Honor.
Mr. Lally, earlier when you talked about the DNA, you said that on 9/26, one item, the testing should be complete, the other, the last week in October, and then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 9/26 day was in reference to the DNA work that was completed on August 1st.
Yes.
That was the second round of exhaustive testing in which their expert, Mr. Lakin, was present. That we had to delay because of first his availability and second not having the exhaustive testing form completed. The second that I was referring to in late October is in regard to two separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office, for DNA testing. That has just, they don't require exhaustive testing. So that has just begun to be, I think it's scheduled within the next week or two to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions. Every single bit of testing that's been done, as per the court's suggestion and direction, I've requested expedited analysis with regard to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
All right. So what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been tested. And I want the Commonwealth to be able to report back in the beginning of November the results of all of the testing that's been completed. And if it's not completed, why, and when you expect it to be completed. Why don't we have all of that by November 3rd? For B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth. Your experts need to talk, and you need to put something in writing for me on that. Stand up at the microphone so I can hear you.
Can we have a compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on a disc and in the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay, so if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced. All right, so the request D, is the Office of the Medical Examiner, is that all taken care of? The original death certificate? You didn't raise that this morning, Ms. Little?
Yes,
so, okay, so request number 5 is all set?
Yes, Your Honor.
Okay, so regarding the request for all of those notes, a 2-week date. So let's get that by the 29th of September. I'll give you the same time frame to see about whether there are any photographs, handwritten notes, mapping, documenting the recovery, the 5 undocumented searches that are outlined in E of the defendant's response, reply to the Commonwealth's response. So 2-week date for that, 2 Commonwealth 929. The Commonwealth says that there is no raw data with the CERT team or no notes. Why don't you just tie up all loose ends and put that in writing, Mr. Lally, by 929.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Okay. That was the whole purpose of today's hearing, was to be able to do that. So at least we've got that done. Now we move on to the Commonwealth's motion for an order regarding expedited testing. And the Commonwealth has asked me, I believe, to impound the results here, Mr. Lally?
As far as the attachments to the motion, yes.
Yes, okay. Is there any objection to that from the defense?
Let me have just a moment here.
Welcome, B. May.
Your Honor, I'm sorry. Did you say expedited testing or were you referring to exhaustive testing? Is that what you're asking?
Exhaustive testing, the Commonwealth's
Okay.
motion.
I'll let you address that.
So, okay.
Your Honor, there is an objection.
Okay, so let me hear the Commonwealth end of the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments?
No.
Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. And Mr. Clerk, the results that are attached here, Commonwealth satisfied me that they qualify for impoundment, and I will impound them.
Yes, Your Honor. Duration of trial.
Yes, I'll put that in here. All right. So Ally, I'll hear you on the exhaustive testing motion.
Yes, Your Honor. So very simply put, there is two items that, as I just referenced earlier, had been subject to DNA testing in July of this year. Among those items was the root end of a hair, item 3-6.1, from item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting being done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of the size of essentially what is the shaft ends of the hair. For those reasons, the Commonwealth is requesting that it be permitted to send it to Bodie Technologies in Borton, Virginia, which is a lab that the Commonwealth and Defense routinely use. I don't think there's any question as to the ability of the lab to do said testing. I've also attached as Exhibit C, reached out to Bodie just because obviously, whereas it would be exhaustive testing, we were curious, or I was curious as to whatever their policy was regarding observation of testing procedures. They do somewhat allow for it, but it's more of sort of behind glass. And
It was helpful to me to be able to read it.
So for those reasons, whatever, I mean, that is something I think that is up to the defendant through her counsel as far as how she wishes to exercise that. And I'm sure whatever the choice is can be arranged with the lab. But whereas the testing is exhaustive and would be sent to an external vendor, I felt that a court order was appropriate in order to, prior to sending that sample off and conducting that testing.
So you are not asking that I impound Exhibit C?
It certainly doesn't have to be. I just did it as A, B, and
No,
C.
the only thing that requires is A and B. So I'm only impounding A and B.
That's fine now.
All right. All right. Now I'll hear you, Mr. Jackson, on your opposition.
Thank you, Your Honor. As it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior, it turns out that it wasn't a human hair. On August 25th, 2023, there was DNA testing done on 3-6.1. And the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, so 19 months or so, of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th, after they had this document in their hand, which the highlighted portion says, no human DNA detected, they filed motions with the following phraseology. Quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times. And the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious and it's intentional. So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which would, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue. And it's not like a generalized proficiency exam. It's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it. My position is it should not be destructively tested, certainly not by the Commonwealth. I understand, I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically, make their own determinations. At that point, Mr. Lally, myself, we can agree if, in fact, the results are satisfactory to have it exhaustively tested, but certainly not now. Not after this, as I said, tortured history of this item.
Okay. So am I going to hear from Mr. Lally or Ms. McLaughlin, who wrote Mr. Lally, I'll hear from you.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department, labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair. I believe what has just been stated is a complete misrepresentation of what that DNA testing report says. So what the DNA testing report says is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis, the second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA typically in typical DNA testing from the actual strand of hair, which you're using the root end in the hope that there are some residual skin cells that are left from that root end in order to conduct the testing. So when they get to the second step in this particular analysis, the quantitation, there is an insufficient amount of any DNA to be able to generate a sample or a DNA profile from. That's what no human DNA detected means, which I'm sure counsel is well aware of in its representations to the court to the contrary. So the STR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step. So the findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item. So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there's nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their observation policy and because of the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson, I just want to know the answer to this question. Did they give you a timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
At the end of the day, all we're asking for is to have the item reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lowley's response, and I understand why he's responding this way, well, there was no deception here. We weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes. It looked like a hair. Why didn't they say that? Why didn't they say it looks like a hair as established by our expert who failed her proficiency examination? That would have been a truthful statement. But the statement that they've repeated over and over and over to this court in papers and in affidavits under oath, under penalty of perjury, is the hair has been forensically confirmed. There is no, you can't word salad your way out of that. Forensically confirmed means it's been DNA tested to confirm forensically and scientifically that it is a hair. Then they turn around and try to confirm it forensically, and there is no human DNA detected. I understand that the short tandem repeat testing, the mitochondrial testing, has not been done yet. That's their 11th hour sort of Hail Mary to try to cover themselves for what they've already done, which is to basically defraud the court. And not one, but two, but three, but four different filings. 3 in front of this court, 1 in front of the Court of Appeal. It just doesn't pass the smell test. What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road. We want access to that item so that we can confirm whether or not it's even microscopically been properly analyzed. That's all we're asking. And I'll submit.
Can you get me an affidavit from your expert as to why photographs are not sufficient?
I can, and I can, as an officer of the court, I can certainly indicate to the court that this has been done enough. I'm experienced enough to know that they can't do it vis-a-vis even a micro photograph. They have to see the item in person, but I can get a declaration to that effect.
And how the procedure would be conducted and how long it might take. Put all of that in writing for me, and I'll consider it when I consider this motion.
Thank you, Your Honor.
I'll consider it. Why is that not an easy
All right.
yes?
So
Why is
we'll
that?
move on to Mr. Yannetti's motion as to why I should change the conditions of release.
Thank you.
Why
Your
is that not an easy yes?
May it please the court, I appreciate the opportunity to be heard. Your Honor, I stand before you because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make this request because there are numerous important changed circumstances that have come to light since bail was last considered and modified. We also make this request because my client's finances continue to be drained and depleted as she struggles to pay the multiple experts she needs to properly defend herself in this case.
So before we go any further, I saved this motion to the end because you indicated that I would have an affidavit from your client as to her finances. I do not have that.
Yes, I did not file that electronically. I had told your clerk.
But I still don't have it now.
I have it in my hand, Your Honor.
So that doesn't help, does it, Mr. Yannetti? I need to read it.
No, I'm happy to pass it up.
So just give it to me and let me read it.
I just need to clarify, these are expenses since the last bail hearing.
All right, so give me a minute before I hear you on
Yes.
this. Has the Commonwealth seen this?
I'm filing it ex parte. So no, I have not.
So they had asked the judge to recuse herself. And said she was biased and she wouldn't.
All right, so Mr. Yannetti, you've seen, I imagine, in your time as a prosecutor too, you've seen affidavits of indigency.
Yes.
This doesn't give me enough information.
Well,
doesn't give me enough information under Brangen, doesn't give me enough information at all.
My client has expended multiple, fees to not only experts but also to lawyers prior to the last date as well, Your Honor. In terms of qualifying as indigent, I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to this particular case. That and there are also, I should say, many more expenses to come. Many of which have been already discussed by this court with regard to the multiple experts.
Do you want the opportunity to file a proper affidavit under Brangen? This doesn't give me the information that you know that.
We're happy to do that, Your Honor. I would still like to make my argument today.
Okay, you can make your, I can't make the findings under Brangen,
Right,
Mr.
well,
Yannetti.
but at the end of the day, Your Honor, if it's supplemented by an affidavit, then the court can make a finding at that point.
Okay, I'll hear you since you're here and you're ready, and we're doing a great job with timing. I appreciate counsel all being succinct today.
I appreciate that, Your Honor. As just continuing with my train of thought, the $80,000, our argument is, it's sitting in the Norfolk Superior Court Clerk's office now, serving no purpose other than to prohibit my client from using that money to properly defend herself. Your Honor, every time this bail has been discussed regarding this matter, both in Stoughton District Court and in this court, the Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to with regard to both, I'm concentrating my argument on changed circumstances. With regard to the potential penalty, in light of the changed circumstances that have and will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There is no jury anywhere who will ever vote to convict her for a crime she did not commit. And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee, because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence. By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie. Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. And he told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m., she is innocent. But Your Honor, it's not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found.
Ford Edge.
Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons knows exactly what happened to John O'Keefe. That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled "Hoslong to die in cold." You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found in my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, that information was kept from you. It is now yet another change circumstance that justifies the lowering of Ms. Reed's bail. Now, I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and two, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed.
He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2:30 a.m. Jennifer McCabe Googling how long to die in cold at 2:27 a.m. and then 3 minutes later, Brian Loughran driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail argument? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the appropriate time.
I don't need to see a chalk, Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan. So I will hear you because you want to make this statement. So go ahead, but no chalks.
Wait, you're right. Just so we're clear, it's not just her financial status that justifies reducing the bail. The thrust of my argument is all with regard to changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
Yeah. And obviously my argument is, leaving the financial issues aside, the bail should be lowered based on my argument here today that I'm making to this court. I had just stated, Your Honor, that in order for that, the microscopic supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend.
Thank you.
Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that a street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily, thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing was not submitted to the lab, Your Honor, until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's in a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took, so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m. and Brian Loughran went by and saw no body outside that house 3 minutes later. So legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that will go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return. I would submit there's nobody in this courtroom who believes my client is a flight risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere. Her family's here, her doctors are here, and given the strength of her defense, as illustrated by the changed circumstances we've discussed, she has every incentive to fight this case and no incentive to flee. She's made every court appearance and has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to sign a waiver of rendition, any waiver of rendition the court would desire. So on this issue, she's really figuratively putting her money where her mouth is. Giving her passport and a waiver of rendition is far more valuable to this court in terms of assuring her appearance in court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth has unlimited resources. My client does not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you. Do you want time to provide that affidavit to me?
I'd be happy to do that, Your Honor.
How quickly can you do it?
We have 1 week.
Okay.
Thank you.
Yes. Mr. Lally?
Just very briefly, Your Honor.
So now y'all see why this
Commonwealth just request that the bail remain the same. There's no change in circumstances of the
please.
facts, and I use that term loosely as Mr. Yannetti was recounting for the court. Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into a great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts, or is Brian Albert's Ford Edge, or something to that effect. What he leaves out from that interview with Mr. Loughran is that Mr. Loughran specifically says that Ford Edge is not Brian Albert's Ford Edge. Another sort of interesting issue in relation to the affidavit from the investigator in regard to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners.
There's so
There
much
is simply no evidence.
There's so much evidence. There's so much
Yes, now
evidence.
it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone. The court has been provided numerous reports from forensic experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear, that from her analysis of that search was conducted respectively at 6:23 a.m. and 6:24 a.m. It is not a mystery as to when that search was conducted or why that search was conducted. It was conducted by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's financial resources, again, those were filed ex parte and as the court, so I really can't speak to those. All I can speak to as far as financial resources is this case was initially arraigned in the Southern District Court. The court set a cash bail of $50,000. The defendant posted that within minutes. The defendant was then arraigned in this court. The court set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within minutes. If the court is inclined to reduce the cash bail, I don't think it's of much moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously. On February date, if the court were inclined, I would concur with surrendering a passport. I would concur with executing a waiver of rendition, and would ask that there be an additional order, the defendant be ordered to remain alcohol-free, subject to random testing with a scram device, based on the nature and circumstances and based on the indictment she faces in this court. Thank you.
Okay.
If I may respond briefly to 2 points, Judge.
Okay.
First, with regard to the DNA being a match or a presumed match of John O'Keefe, what Mr. Lally didn't tell you is that that sample was a mixture of John O'Keefe and 2 unknown people. So I don't know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people and the other 2 people somehow got away. But that doesn't make a whole lot of sense. The second thing is, with regard to the Ford Edge that Brian Laughlin saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen a body and known or not known that there was a body there. But finally, with regard to that point, Mr. Laughlin was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
You can't
So,
get justice.
Mr. Netti, I need that affidavit by next Friday, so I'll take this motion under advisement. All right, so I said at the beginning that we need to set dates, and it's been mentioned that there have been a couple of pretrial conference dates. There have, but counsel have not complied with the Superior Court standing order that we need to get back on track. So Superior Court standing order 2-86. So we need to set some dates. And counsel has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding a pretrial conference. So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Oh, here we go. Proposed trial dates.
Your Honor, it would be the defense request, and we're open to the specific date, but we would like a trial date in March of 2024.
Okay, that's great.
Early March would be better if it's available.
So we have a trial that's starting in January, a retrial that last time took 6 weeks. So I think mid-March would be better for us.
Okay.
Jim, can you suggest dates?
Yeah, how is March 12th? 12 or 19?
12 would work. Is the court's preference, just going by what Mr. Riccone said, start off Tuesday?
Yes, we typically do Tuesday.
Yeah, because civil and handles on Monday.
Makes perfect sense.
Yeah.
Does that work for the Commonwealth as well, March 12th?
March 12th, yes.
So,
fine, Your
as a result of that, can we have a final pretrial conference sometime the end of February? Maybe 26, 27, 28 in that time frame? Is that okay? Is that week good?
We're
Oh, I'm
just
sorry,
checking.
Yeah, go ahead.
It's good for me. I just want to make sure it's good for me.
Yeah. Fine.
We do the 26th. Would that be available?
That's a Monday, we can do that.
That'll
be at 2 p.m.
I was just going to ask. 2 p.m.
Yeah, and we expect you to exchange motions and eliminate any potential voir dire questions, as whether or not you want to do a panel voir dire.
Great.
So that we can talk about it on the.
So those, and the dates that I gave you, November 16th and January 5th, those are out-of-court dates. Have all your motions filed on those dates. And give me a realistic date that you all can file your pretrial conference report. I suggest it be around November 3rd. Maybe we'll do November 3rd. Does November 3rd actually work?
Can you do November 3rd?
Yeah, November 3 is fine, Judge.
All right.
So that's just the final pretrial conference and that's that.
Yes.
Yeah.
So we currently do not have an in-person date until we see about those filing of motions from January 5th.
Does it make sense to have an in-person date of November 3rd, Your Honor?
It does if you want, but you've talked about the expenses. It doesn't make any sense to fly people out here if it's unnecessary.
My suggestion is that Jesus will we would like to have a person hearing on the 3rd.
Okay.
Sure if there's any T's that need to be crossed or I's that need to be dotted.
I'm not available that day.
Okay.
That week, actually.
That whole week.
I'm on trial.
Can we pick a date the next week? 6, 7, 8, or 10?
10, it says Veterans Day observed, but I don't know. No, Jim, let's actually do the following week. Let's do the 16th.
So, November 16th, can you do November 16th?
And I'm sorry, that's for what event?
This next in-court date, we can't do the 3rd.
Oh, you can't do the 3rd, I'm sorry, okay.
The 16th.
That's the date that you're to file all non-evidentiary motions by anyway.
Yeah.
Can I ask you, Counsel?
Jim.
Yeah. Thank you.
My counsel makes a good point. Maybe, I'm sorry.
I know. I don't want to use that week.
Yeah.
Go ahead. I was going to say, Your Honor, it may make sense to do it maybe a couple of weeks later after we've filed all the non-evidentiary motions. Could we potentially do December 1?
No, that's the Superior Court judge's business meeting.
I see.
You can do the following week. You can do the 8th if you want a Friday.
Following week, the week of December 4th.
Let's do the 8th, Jim.
The 8th,
Friday?
can you do the 8th of December?
Yeah, the 8th works. It's fine.
Is that okay? Great. 12/8 is the next in-court date.
9 o'clock, Jim.
9 o'clock, okay? Everybody? Great. 9 a.m.
Yes.
Thank you.
Thanks very much, Your Honor.
Thank you, Mr. Clerk.
All right. Jim, I'm going to keep everything with me. Goodbye.
Just him ending.
Agreed. I can see you in a bit. Tori, thank you very much.
Yeah, I've been talking to him. I want to go to, let me see if I can pull back up. Because Turtle Boy's there right now. I showed a little clip of his protest this morning before we got started. But he'll be live again in a moment. He's already live again.
They were coming out of that room there, so they didn't even have the balls to come in. Those punks.
Little boy, good job.
Oh, thank you, sir.
We'll watch a little bit of them coming out.
No, you'll know. You'll know when he's here. You'll know. I'll be greeting you. Yeah, they did very good. It was a good showing by Karen's team. We'll
Right.
see what she does with all those.
With her walking out, they're about to go crazy.
That were made for the first time. Lucky Bev's face when they first started talking about Lucky Laughlin for the first time in court. I noticed her eyes lighting up. So, Auntie Bev's face. Get out of my face. So, Lucky Laughlin.
Yeah, Lee, you can
Touch you, Brian. You look like a leopard.
email them to me, Brandy at brandychurchwell.com.
Please.
Let's see. Hey, does anyone want to see real Turtle Club? I can show it to you right now.
Oh, you know what? Can you do it now?
They're getting tense out there.
Take it off of I have a USB drive. I mean, I just recorded it to a SSD drive. Yeah, go get it. Yeah. Sure.
Yeah, you guys got the. Maybe you guys should plug up the stairs, and then this wouldn't happen.
All right, so if I'm outside already, I can be ready. So just get. Where are you from? You're from? Okay, yeah, listen.
Press conference, if they give one. But at the same time, I
What, give me a card. Okay. So I'll be up front.
Can I have a quick second? First of all, I want to thank everybody for coming, everybody that's supporting Karen.
This is Turtle Boy's
channel. I want everybody to know that we see you and we hear you very, very clearly. A couple of weeks ago, District Attorney of Norfolk County, Michael Morrissey, decided that it was a good idea to issue a statement, a public statement. And he decided to talk about this case. And I want to take a minute to talk about that. Before I start talking about the specifics,
Open up the stairs. Open up the damn stairs. This is ridiculous.
That's the fake media over there. We got the real one right here.
Let him speak.
Let him talk.
Let him speak. Hey guys, come on. Before I get started talking about the specifics of what Michael Morrissey said, and I've got a rebuttal, as you can well imagine. I want to talk about one thing first. There are rules of ethics. There are rules of ethics. There's rules of law that prosecutors must follow. The Massachusetts rules of ethics state the following. Any statement by the public, by the prosecutor, any statement to the public by the prosecutor shall at all times take care to not imply guilt at any time or otherwise prejudice the interests of the accused. Does anybody here think that Michael Morrissey had any other intent but to prejudice Karen Reed? That's exactly why he was saying what he said. But Mr. Morrissey doesn't care about the law. He doesn't care about the rules. He doesn't care about ethics. And he's going to have a lot to answer for with the state bar at some point. In the meantime, since he decided to release this disgraceful statement, I want to address a couple of things. First, it's become very clear that Mr. Morrissey and his office, they don't want to meet. Mr. Morrissey decides to use a cheap stunt, if you will, and launch this appalling video in a failed attempt to salvage his reputation and to salvage.
I don't know. We lost his feed. I was looking to see, I'm trying to find the camera that's outside of there right now. And I can't find it. Let's see.
From an animal attack. He said that the medical examiner said this was not from an animal attack. I would highly recommend that Mr. Morrissey actually read witness statements before he starts pontificating about them. Here's what the medical examiner actually said. First, she said that she was unqualified to make a determination as to whether or not they were animal attacks. Does that sound familiar? Yeah. Unqualified. And here's her actual statement. Quote, in this particular...
All right, hold on, let me see. Let me go to... For some reason, his keeps cutting out. I'm trying to find the
Today, the woman accused of killing her police officer.
That's not it either. Let's see.
Particular case, all I can say is that the injuries are
Comes
there.
back sometimes.
I documented them, I measured them, but I can't tell you what caused them. That's what she actually said. And then Michael Morrissey decides to get up and stand behind his desk and issue a statement that he knows to be false. There's no way to misinterpret. The next thing he says, every one of the witnesses for the government have been forthcoming. They've been forthcoming. Forthcoming means truthful. It means honest. It means transparent. That's what forthcoming means. And these witnesses have been anything but. Not a single witness originally admitted that Colin Albert was ever in that house. Not one. We had to figure that out.
Yes.
Nettie and I had to figure that out.
Yes.
Unbelievable. The next thing that you should note, Mr. Morrissey should probably note, is that the Commonwealth is damn well aware that Jennifer McCabe scrubbed her cell phone of nearly every communication with the Alberts on the night and the morning that John was killed. And she intentionally deleted that now famous, infamous 2:27 a.m. Google search of how long it takes to die in the cold. Again, truthful, honest, transparent. These witnesses have been anything but, Mr. Morrissey. So you should watch your statements and read the witness testimony and know the evidence before making statements. And speaking of the authorities, Mr. Morrissey went on to say, quote, Michael Proctor was never at Fairview Road on the day of the injury. Take a look at this. That's an interesting statement. That's an interesting statement for Mr. Morrissey to make. His official statement of the case that he released to the public, says, quote, later that morning, the Massachusetts State Police Detective Unit of Norfolk District Attorney's Office was notified and responded to the scene. His words, not mine. And in case that left any doubt, he cleared it up with the next sentence. Trooper Michael Proctor, and Sergeant Yuri Buknik were among the troopers who what? Responded to the scene. And now he comes out a year and a half later in a desperate attempt to taint the jury pool and says they never responded to the scene. So I have a question for Mr. Morrissey. Are we trying them? Or are you lying now? Which can't have it both ways. And finally, he personally vouched for his star witness, Michael Proctor. He said Trooper Proctor has no close personal relationship with any of the parties in the investigation. And that's a quote.
Get him out of there.
Folks, I got one thing to say to Mr. Morrissey. A picture is worth 1,000 words.
Yes.
What do you think this is? Not only is there a close personal relationship, Michael Proctor's own mother, his mama, said the Alberts are a second family to our family. It doesn't get any more close than that. So you may ask yourself, I'm sure a lot of you have been asking yourself, why would the sitting district attorney of Norfolk County decide to make a statement that he knows includes provably false statements, just out and out lies? Why would he do that? The answer is because they don't like, the DA's office doesn't like the story that the evidence is telling. They just don't like it. It's a story of corruption, an inconvenient truth. There's corruption in their little town. There's a cover-up in their midst. And Michael Morrissey doesn't like it and doesn't know what to do with it. So instead of going out and actually finding the culprits who killed John O'Keefe, he decides to hide behind his desk and released a cowardly statement specifically designed to taint the jury pool, to poison the jury pool, because that's the only way he thinks he can win. He talks about his precious witnesses. He talked about his precious witnesses being inconvenienced, his precious witnesses getting their feelings hurt. He talks about his evidence case being capsized by the evidence, and he doesn't like it. So you know what he does? He tells us, he tells you, stop it. His words, stop it. He wants us to quit. We won't stop. We won't stop. wants to issue this statement and give you a threat and give us a threat. He wants us to just shut up and quit. He wants you to shut up and quit. Quit with all the evidence, quit with all the motions, quit with all the arguments. Just go home and quit. Well, I have something to say directly to Mr. Morrissey right here, right now. So listen up, sir. And I'll speak slowly so you understand.
Wow.
Morrissey, we ain't got no quit. Will not quit. And I can guarantee you, Karen Reed and her family will never, ever quit. Not until the Donald killers are brought to justice.
Karen
I
Reed's
want to
gonna
thank
bring
you
our
so
faith
much
back to the
for your
groove.
support. And we're not going anywhere. Thank you.
Yes.
Wow.
Great job, Juror.
Like all the support.
Yeah, this is Turtle Boy's team.
Thank you.
I didn't know exactly. Yeah, I'm glad he said something. Yeah, that was great. That was great. Let's see.
Oh, no.
Andy, you want your megaphone? It's charged.
Oh, thank you, sir. Oh, thank you, Tom. Appreciate it.
See you later.
Oh, nice to see you. Yeah. Hopefully, it's the last time we ever set foot in this courthouse. Yeah. Yeah. Sounds good. See you then, Nate.
Photos. Take care.
Yeah, absolutely.
Right here, the man, the legend. Right
Yeah,
there.
absolutely.
Yeah.
Journalism Jesus.
Journalism, Jesus.
You're welcome. Thank you.
Oh my God.
Oh, in the house.
Can't salute.
Yeah. Look, he's in my way.
Thank you.
He's already been warned.
Yeah, you got it? Oh, I thought he was in the way.
All right. Good. Oh, yeah. One more. Yeah. Can't salute. There we go. Yeah, absolutely. Absolutely. I know.
Look at him. He's like a celebrity now. Turtle Boy is.
Going back 30 years, and that's all we're asking is that we are not left out of the dark and we're provided the same information that we have access to.
Audio and Melly's hearing is awful, of course.
We have the ability, and I'm just going to use the example, there was a young lady testifying about a murder that occurred with her uncles. They were able to find the case.
Yes.
Several times actually.
All right, I'm pulling up the pictures.
So if you get information on something, you file ID on prospective juror or jury court talks, whatever. Yeah. What type of information would be in that case was some conviction, so you can share that with the, where you make a statement, before.
So here's some of the.
But like I said earlier, that was not what they're doing, that was not set for a motion.
I didn't set it for a motion hearing because I was waiting for, like, in the response saying, whenever investigation on a prospective juror.
These are pictures outside the protest.
That's basically all we're asking. We don't have that access to certain information. We would have never found out about that one juror that this liberty just mentioned. Obviously, they had a quicker way of doing it.
That was because she disclosed it, she mentioned that her family member had been a victim. So we asked her for the name, she provided it, and that's how we were able to do it.
So many people out there, and this is just for a hearing, y'all. We'll keep Turtle Boy just down here. Oh, he's turning off anyway.
Do you use jury selection? Journal? Use the driver's license there?
Those are great.
Okay, no problem. No problem.
Short order to say you can't use because Dave is not being used, CIC is not being used, but whatever is being used, if either side finds it, they agree to share it with the other side.
Judge, may I inquire, and I know you had told us the last trial that you don't do the jury questionnaires that came.
Just so you understand, that's.
Their audio is terrible. It has a lot of background photos. Thank you for sending those in. Thank you so much. Can I use some of those? Can I show some of those on my Twitter? I won't do it without your permission, but if you say it's cool, then I'll tweet some of them out. And if you have Twitter, send me your Twitter handle and I'll tag you.
Messages from jurors that they want their names out there.
No cameras in the courtroom for Coburger, no audio either. Ugh.
They want to see who's on the jury list. It happened. One case we tried here where jurors at their house when the jury got home. And so what we're trying to do is basically let the jurors be free from anyone being contacted and things like that. So issue and that's they don't want your for the most part.
It's me, Kim. So I get what you're saying. For me, there's a reason there's all of these protests. This isn't a normal case. And for me, if you like, I want to know the truth. That's my biggest thing. I want to know the truth and I want justice. And there are so many lies, from proven lies from the state, that I don't trust anything that they can say because they've shown us that we can't. So for me, I want to see everything on this specific trial going into it, because I don't trust the judge to be not biased when it comes to letting information in. There is not a calendar on. I gotta turn this down. I'm showing this because y'all want to see it, but honestly, I'm so over Melly. I really could care less. They've been fussing all morning. I've been checking the updates, but really, they're just waiting to see if he's going to get bond. They're setting the new trial. It's going to be Monday through Friday instead. Raven's still whining. That hasn't changed. I'm over them. I'm over them, but all right. So I don't have that's actually a good idea though, Kathy, because I have a calendar that I mean, that white noise is so you hear so much more white noise than you actually hear audio. So I can look into trying to do that on the website on maybe on the 13juror.live website. Let me see what it would take to put my calendar on there, because I have a calendar with a Google Doc that I keep with all of the different stuff that I'm covering, so I know when the hearings and everything are. So I'll look and see what it might take for me to get that. That's a good idea. All right, let's see. So what do y'all think? Again, I'm muting this. We can look and see what they're doing. But when I get the notification that he's actually going to talk about, or the only thing I'm really interested in with the Melly is I want to hear what the judge says about his bond. Obviously, I have my own thoughts on that, but we'll see. I am, oh, this is funny. Shocker. Shocker. So what do y'all think about this one? The case, for those of you who, I know a lot of you hadn't heard about it. A lot of you had heard just a little bit. So a lot of you hadn't heard about it until I did the podcast. So I'm curious to know what your thoughts on it are. Yeah, Angie Brown, I have a podcast on Karen Reed. The first episode was released last week. It's under 13th Juror podcast, and it's season 2. So I'm going to continue doing like the recap podcast stuff of the trials that we're following, but this one's going to be like a whole deep dive. I've done a lot of research on this and put together a bunch of stuff, and then some of the stuff too is like I mentioned, Sleuthy Goosey and Turtle Boy both have put a lot of work into this too. So I reference them in there too. So they've got, Turtle Boy's done a lot of digging, and he knows, like, he's in the area. So he has done a lot of digging on some of the connections of the people too. So I've got some of that in there, and its first episode was out Monday. I don't think I'm going to do a Monday release again, though. I think that was a mistake. I think from now on, the episodes are going to be either Tuesday or Wednesday released, because Mondays are too Monday to have a deadline. So is there evidence of hit and run in the autopsy? No, not even a little bit. So that's one of the big problems with this too, is that they're saying that the state is saying that she hit him and that somehow busted the taillight. Do you know how fast you would have to be going to hit somebody? My hip like itches. I feel like I got bit by something. Oh, it's a tag. No wonder. Don't mind me. Don't mind me. Just cutting out tags from my britches. Oh, that's so much better. No wonder. Okay. The taillight, for it to be broken, think about how hard you would have to hit some. Have you ever tried to break a taillight? I mean, normal people, I guess, don't normally just try to break taillights. But if you've ever tried to break a taillight, that's not just something that that's not an easy feat. You don't just easily crack a taillight. Those things are like built for some, for some impact. So for that taillight to be broken, but there to be no other damage to the car, everybody's like, no, why would we try to break a taillight? That's stupid. But okay, and I realize that's a rhetorical question, I guess. I used to work in a body shop. I worked in a body shop for years. My dad owned a body shop. I did paint and body work for years. Right when I got out of high school, when I was in college and stuff, I painted cars and I did body work. So you could drop a dang taillight and it won't crack, on the hard cement floor, and it won't crack. So to me, there's no logical explanation of how the taillight could have broken with him hitting, or with her hitting him, but yet that's the only damage. So that's my problem with that. The video of her when she's leaving John's house, because she'd gone back to John's house and gone to sleep. The video of her when she's leaving John's house shows her backing up her car. And I even mentioned this in the first episode of the podcast. Like, you can see her backing out, and it, like, you see her like just barely run into John's car, which could be how a taillight cracks. And that to me makes a lot more sense than be right back, gotta go break me some taillight. Look, they even have break rooms now, like where you can like go and like break stuff to get your aggression out and stuff. So it's not that far-fetched. So the video showing that she hit his car when she was backing out of the garage, that makes sense on breaking a taillight. Hitting him, but hitting him hard enough to break a taillight, but yet doing no other damage to the car does not make sense to me at all. Call me crazy. I've been called worse, but it doesn't make sense to me. So it's one of those things that I question. Now, their story is that she hit him and then backed over him, and that he, like, the parallel lacerations on his arm are from being run over. Well, it was that he got hit by a plow, and then the plow driver, you know, was able to be found, and, you know, he didn't get hit by a plow. So, anyway, the story now is that from the state is that he got run over, and that caused parallel lacerations only on the right arm. That math ain't mathin' to me, but maybe some other, you know, experts understand it in a way that they think it makes sense. But the theory that he was talking about the dog and how, you know, he lied about the dog. They lied about the dog not having any history of biting people. And they mentioned Colin and they mentioned Brian. Let me pull up my, so in the stuff, and I have these on Twitter and on the website here, but Brian Albert and Nicole Albert are the ones who live in that house. So Brian Albert, the dog was Chloe. And this is the one that they said when he was saying that that Brian Albert had a Ford Edge, and that they had said, oh, that wasn't his Ford Edge. But he said, well, you know who else does? Colin Albert. Okay, so here's why this, and like I said, I've only done episode 1 of the podcast just as an introduction, but I'm going to, as the season progresses, I'm going to go very much deeper into all of this. But the Ford Edge, they're like, oh yeah, it wasn't, they said it's not Brian Albert's Ford Edge. Okay, but Colin Albert also has a Ford Edge. When everybody was like, yes, thank you, finally getting the information out there, and started like applause and stuff like that. Colin Albert has a Ford Edge. Colin Albert has a history of having, you know, issues with John. Colin Albert, there are pictures of him with like beat up knuckles and stuff. They admitted or said that he got to his, you know, to a house like down the street. But yes, Lisa Wilmot, we're going to watch paint dry after this. That's our next plan. Watch them paint dry. Fresh new look on it. Don't say fresh. Okay, so the pictures that they were talking about during the hearing where they're like, Proctor, the main detective dude, you know, the main one looking at all of this, the one who found the taillight pieces and, you know, had the 5 different undocumented searches where he happened to find taillight, but yet nobody knows anything about those searches and nobody has any kind of record of any of those searches, but yet now he has it. Proctor, the same one who had, you know, pictures of him in the hospital when they were trying to show the chalks and they wouldn't let him show them. They, you know, John O'Keefe is in the hospital bed and Proctor is standing in there and John O'Keefe's clothes are like, you could see like that messy pile bag thing, you know, at his feet. So he had his clothes. There's about an hour and 18 minutes where Proctor is alone with the car because there were times that were wrong. Whether I'll just say wrong. They were incorrect times. So there was a whole like hour and 18 minutes where he was alone with the car. And then all of a sudden after that, they're finding taillight pieces. He's having undocumented searches. So this is Proctor, right? Proctor is in family photos with Colin Albert, the other one who has the Ford Edge, when everybody started clapping and they were like, yes, thank you, Colin has a Ford Edge that was parked right by where the body was. And the snowplow driver saw it. Colin Albert drives a Ford Edge and is in photos. He was in Proctor's sister's wedding. There are pictures of them together. There are 10 years worth of social media posts where Proctor's family and the Alberts are showing like, you know, oh, it's my favorite boys. And oh, you know, love them so much. And so, and that's why everybody in the gallery, when Lally said there's no evidence of Proctor being close to them, that's why I laughed. That's why the whole gallery laughed. It was one of those things like, are you freaking kidding me? Like, this is not, if you don't believe anything about anything, you have to believe that there are ties to Proctor and the Alberts, because it is public. You can go look at it right now. Unless they've removed it. But last time I saw they hadn't removed it. I mean, this is not one of those situations where, you know, like I said, I'm not usually big on conspiracy theories, but this is not one of those situations where it's an off the wall. It would take, you know, like all of these different stars lining up for this to work. The fact that, because even here's the thing, and here's my number one thing with this. Even if the theory of how John died is not correct, that part to me right now doesn't even matter. What matters to me is that they are lying. They are publicly lying. They are lying on court documents. They are lying to the public. They are lying to everybody. And that is the part that should scare the shit out of everybody in Massachusetts. Because for whatever reason that they're lying, that's preventing justice. And y'all know me, my number one thing, I want justice for the victim and I want the truth. And you cannot have one without the other. If they are lying about all of these things, that's a problem. And if so many people who are so close together are lying, that's a bad look. So how are people not going to think that something else is up? I just think it's one of those that, it's one of those that's, the more I started digging, the more I was like, holy crap, this can't be true, right? That's not true. And then I would verify and I'd be like, you are freaking kidding me. I mean, okay, let's talk about the whole, I don't have any relation to, or the proctor doesn't have any relations to the Alberts. When they tried to show that in court, and they because this is not, and as we go through this, like I said, I'm going to show all the previous hearings. We'll stream them together and watch them as I go through the podcast. Each week I'm going to release another episode. So we'll watch the hearings, as they come up or whatever. And I'll have streams that kind of coincide with the release of the episodes of the podcast. But there's a picture. I think, maybe I don't have it. I don't think I do have it on there. There's a picture though that has Proctor and Proctor's niece are like kind of in the front of the picture. And then two of Jen McCabe, the one who Googled how to die in the cold, and she was at the house that night. Two of her children are in that picture. So when they tried to say, hey, this, he has obvious connections to this family whose house he went to investigate a dead body, he is obviously not the right one to do this. They dismissed it because they said that picture is one of the, I can't remember how exactly they worded it. I've got all the court documents saved, but something to the effect of, that's not substantiated. That child in the picture is a relative of Proctor's. They didn't mention the two in the back. They didn't say, because they can't, because they know it's a lie. They can't say, oh, that's not true. Those two girls are not McCabe kids. Those aren't related to the Alberts. They can't say that because it's a lie. So all they can say is, so it's like they completely ignore that whole part and just say, oh, no, that kid in the front, that's a relative of Proctor. Yeah, no crap. We knew that. But they don't, so it's like, it's just stuff like that all the time. It's just constant. And the cojones to just lie on court documents multiple times and not worry about consequences is so, it shows exactly where they stand on this, because if you can lie multiple times in statements and court documents and, to the public and to whoever else will open their eardrums and listen to you, if you can lie that much with no fear of consequence, that shows you right there that there's more to this than what they are showing us. And I mean, no matter what theory you believe of how it happened, there is a conspiracy of, if nothing else, there's a conspiracy to put out false information or give false information. So, and that's a conspiracy each side is accusing the other of. Prosecution saying y'all are just trying to put out false information and, win in the court of public opinion. Defense is saying y'all are putting out false information because we can prove you're lying. So it's like, I look like a picture. Do I look like, I don't want to be a part of this family. Our family's scary. So yeah, so that's that. There's a lot to this one. And I mean, the reason, okay, when they were asking for the notes, let me show you like a little example of some of the timeline stuff I've put together. This is a rough draft. I haven't put everything in and I haven't factored everything in. This is just some of it, but this kind of shows you. So like the stuff that's highlighted in different colors is from different reports or whatever, but there are different things, like different stories behind each one. Like there's one that said, there's one from the PCA. It says that Jen saw the car move from the original spot in front of the house to the left, that she saw it move. Then there's another one that said, or that she saw it drive away. Where did it go? Oh, so here it is. Jen texted John hello and then saw the car drive away. But then there's another one where it says, the next time she looked out the window, the car was gone. Okay, so which was it? Did she see the car drive away? Or did she look out the window again and all of a sudden the car was gone? Which is it? It can only be one. And for statements like this to be part of the record of the evidence against, that's a huge inconsistency, which is why I take every single document and spend so much time going through, and every single time there's a timestamp on anything, every single time I'll put it on there, because that's how you find all these things. It can only be one or the other. So, and if the whole case is centered around whether or not, or if the whole case is about, somebody allegedly hitting somebody with a car and leaving them in the yard to die, knowing that detail of, did you see that car leave or did you just look out and it was gone? That's a huge freaking thing to have conflicting statements about. So this one's so wild. This is why I wanted to cover this one. It's crazy. So I know it's so much going on. My ADHD is on overload. Imagine being ADHD and trying to go through all of the charts and stuff that I do for all of this. It is nuts. It is nuts. Shell says, we talked to one of the police officers at the protest. He was happy that we were there and said we were a great group of people. That's awesome. I just think that, I think that if nothing else, there should be, think about how awful it was. And this part hurts my heart to the core. Think about what a terrible way for an officer, a man who is like, everybody knows is a great guy, he adopted his niece and nephew, took care of them because, their parents passed. Like his sister and brother-in-law within a year of each other. So he adopted them, was raising them, 16-year veteran of the Boston Police Department. Such a good guy. What a terrible death that is. And how could you not want justice for that? How could you not want justice for that? But you can't get justice if you're only getting lies. So if nothing else, and if they start telling the truth and it points to Karen Reed, okay, fine, that's justice. But the biggest concern that everybody should have here should be justice for John O'Keefe and getting the truth out of everybody. So, the theory is that the Alberts, who were at that were, in on it. Maybe there was a fight, something got out of hand. The dog, obviously if a dog sees somebody attacking, sees a fight, it's not crazy not even crazy. It's common for, dogs will attack if they see their owner getting attacked. And, something got out of hand, something happened. And then, in order to protect their own, the theory is they, you know, pin it on her. So it's just, it's, if nothing else, because to me, this is not just about, like, I mean, to me, this isn't about Karen Reed at all. This is her case. But to me, it's not, like, my initial interest in this is not about her, nothing against her. Y'all know how I am. Mine is for justice for the victim. And justice for the victim is getting the truth out there. And if that's, you know, if that's not what's happening, then we should all be concerned. So crazy. All right, let me get a stream set up. We're going to watch paint dry. I'll unmute this for a minute, even though I really am over Millie. Yes, I'm all for theories.
Just a suggestion, and if it's even possible, but I remember back in the day, Judge Lazarus had that foreclosure division over on the civil side. That courtroom was huge. And we used to get in it under.
Lee, I am, if you're still in here, I am about to tweet your pictures because they're really good.
Next door, 2 doors down, 68 4. You can go to any of your courtrooms that are 40. 40. They're all the same size, guys. Okay. It's just your bowl right here on this floor. Makes no difference. But I mean, it's bigger. We might just, maybe not for your question, but at least for the partnerships, it might cut. Whatever court wants to do. Okay. Let's see what that one there now. Okay. Nice seeing you. Thanks, Judge. Thanks for your role.
Have a nice weekend.
All I did is talk about trial and jury and
Next Friday for status count.
all right.
Starting Monday, I want to go to yeah. Do that. We'll do a like a calendar, mark it off, so we will.
Yes, I'll turn it up and run out.
Make sure I get a copy. I know all these things.
I'll do the one for the meetings. We gotta put things.
Share it back and forth, make sure both sides look at it. Whatever you want that we've done. Before you leave.
It was brought to my attention, actually.
Was that on the record?
Yes.
On the record?
The state indicated that the last time when someone recognized Nellie, he asked questions in front of the entire group. And it was brought to my attention, and I agree with the state, that if they recognize him for whatever reason, that can be done individually, we would make that request. And I think the state. Tell court in this case, because then it just poisons the other.
I'm getting the stream set up for us to watch paint dry. So y'all just talk amongst yourselves while I.
When they said they identified who he was or his music, I never asked questions about more than how they know
not what they know, but how do they know something? So I limited my question. I didn't ask.
The court may have, but we, both sides would probably want to pursue that issue, and we're reluctant to do it in front of the entire group.
And so, Your Honor, I could ask very limited questions. Some of the jurors who volunteer statements like,
Correct.
knowing his music and the titles and the lyrics, I couldn't ever presume him innocent. So that was the concern issue.
Okay.
Thank you.
Just remind me.
Yes, sir.
Thank you. Court's adjourned.
Thank you. Nice seeing you. Marty Rask.
I see you. You're like part of the family.
Oh, I'm over him. All right, what time is it now? 10:56. So we'll set this up for 11:15. That gives me just a minute to take Lucy out. All right, and then let me get us portal on over there. We need 404 more subscribers to hit 10K. Kind of cool. Kind of cool. Edit. Save. Okay. All right. I have us set up to portal on over. All right. That should be good. All right. I was doing that and have not read anything because I was trying to get all of that set up. So Amanda Davis, I'm sorry I missed your theory. Email it to me though, and I can look at it and we can talk about it when we do our next one. Okay, so next up on our agenda today, we have, it's going to be about 15 minutes. I set it up for about 15 minutes, so that gives me time to take Lucy out. Oh, she made it down here now. Oh, well, I'm not going to bother with the camera right now. I'll show you when we come back. I'll have Lucy cam on when we come back. I will portal y'all over there, and you, Melly did not. I was reading I did not want to hear Raven's voice. I'm going to be 100% honest with you, but ugh. I mean, I seriously doubt he got bond. No, I don't think so. But they set new trial, or they already had a new trial date set, but they talked about jury and stuff like that. Honestly, I'm not surprised. I was not expecting him to get bond at all. All right, so we are going to go watch paint dry. If you don't know what that means, then it's the fourth murder trial of a woman who is accused of strangling her wife and killing her and then dumping white paint all over her. Crazy stuff. The first two trials ended in a hung jury. The third trial, she was convicted and sentenced to life, but that was overturned because their paint expert wasn't a paint expert. And you are not allowed under any circumstances to say that paint was fresh during this trial. Fresh, that word is not allowed. So no talking about fresh paint. So get out your thesaurus, find other words for fresh. It can be not stale or not whatever. Just don't say fresh. So I'm going to pour it all over there. I'm going to take Lucy out real quick. And then when we get back, we will get started. I have everything saved so that we can pick up right where we left off yesterday. I didn't even close out the browser so that we make sure that we don't have to skip anything. So I am going to portal y'all over there for the paint trial, and y'all, the whole chat will move over there. So y'all chat amongst yourself for about 15 minutes, and then I will see y'all in just a little bit. Everybody's asking where are we going. I just explained it. We're going to watch paint dry. We're going to watch paint dry. All right, y'all. I will see you in just a minute in the other chat.